Okay, hello and welcome to the final Fireside Chat of the year and of this season. My name is Ben Berry. I'm one of the co-chairs of the HK45. Today we are joined by Yoshimi Ohara, who will be interviewed by our very own Jennifer Wu. Jennifer sits on the committee for the HK45. She's a technology, media and telecommunications expert who specializes in commercial litigation and arbitration. She advises on a variety of local and cross-border disputes from general company, employment, IP, to data privacy and cyber fraud security issues. Our guest today, Yoshimi Ohara, is a Bengoshi and a partner at Nagashima Ono and I'm going to try and pronounce this, Tsunomatsu in Tokyo. Described by Legal 500 as an arbitration specialist, Yoshimi's practice focuses on international arbitration, complex cross-border litigation and mediation. She represents domestic and foreign clients in international arbitration in Tokyo and elsewhere around the world, in various venues, under the rules of a variety of arbitral institutions. Yoshimi has a background in corporate, joint ventures, M&A work and intellectual property law, and she has extensive experience in dealing with disputes covering these areas, as well as a wide range of other subjects, including energy, construction, technology, shipping, sales, and distribution. Ms. Ohara also serves as an arbitrator in international arbitration cases. She served as sole arbitrator, co-arbitrator, and presiding arbitrator in international arbitrations under a variety of different arbitral rules and in various seats. What might be of most interest to the viewers today is Yoshimi's contribution to the development of international arbitration as a unique area of legal study. Since 2014, Yoshimi has taught international arbitration on the LLM program at Keio University Law School. Yoshimi served as vice president of the London Court of International Arbitration from 2013 to 15, and the ICC International Court of Arbitration from 2015 to this year. She's currently serving as a governing board member of the International Council for Commercial Arbitration and a board member of the Japan Association of Arbitrators and the Swiss Arbitration Association. Yoshimi is a member of the task force looking into the discrete areas of counsel conduct and conflicts of interest for the IBA Arbitration Committee. So welcome, Yoshimi. We're delighted to have you here today. For those of you viewing, this will be recorded and available on YouTube to see at a later time as well. So without further ado, I will pass you over to Jennifer and Yoshimi. Thank you very much.
Thank you, Ben, for the introduction. I'd like to remind everyone that there'll be a Q&A session at the end, so feel free to type in your questions in the Q&A box. I would also like to thank Yoshimi again for joining us today and for sharing her journey into arbitration. We'll go through different topics and obviously explore different areas as she progresses to her present practice. We'll look at her background, early career, and also diversity amongst arbitration. If we can start off, Yoshimi, can you share with us, when did you realize that you wanted to become a lawyer?
Thank you, Jennifer and Ben, for a beautiful introduction. It is my honor to receive interview today, and I hope my talk will give some guidance or some at least of some interest to you, those working in Hong Kong and working outside Hong Kong. So going to your question, Jennifer, I never thought of becoming a lawyer until I was forced to take a bar exam. Perhaps it was the third year of undergrad. Around that time, we didn't have law school in Japan. We have only undergrad law faculty in Japan. And I never thought of becoming a lawyer, but instead I wanted to join perhaps ministries or join Japanese companies. But there were a few opportunities for female, law schools, law students around that time. But, taking a bar, it is open to everyone. So I decided to take a bar exam, and I was lucky enough to pass the bar, and then I became a lawyer. In fact, in Japan, when you pass the bar, you have three options. You can actually choose judiciary or public prosecutor office or private practitioner. And at the time when you conclude your legal study at the Legal Research and Study Institute run by Supreme Court, you choose one of those three passes. And I decided to choose private practitioner partly because, I wanted to be involved in international practice. And also I found around that time, again, judiciary and public prosecutor office are more traditional, conventional, and prefer. I didn't see much opportunity for female lawyer to have around that time. So I decided to go into private practice.
Yeah. And, in terms of getting your Bachelor's of Law degree in the University of Tokyo, we also know that you later went to do a master's at Harvard Law School. Having studied obviously both in Tokyo, Japan, and also in the US, what differences have you observed during your study?
Sure. The legal education in Japan and legal education in the United States is completely different. And both have good things and, not necessarily good things. Talking about university education, legal education in university, first of all, it's much more affordable compared to the tuition of Harvard. And second of all, well, of course, the affordable tuition is not the best part of the legal education in Japan, but the best part of the legal education in Japan is you get the comprehensive understanding of vast variety of law in Tokyo. So in fact, first 2 years, you have liberal arts study in Tokyo University. And next 2 years, you actually focus on legal study. And during these 2 years, you can take many classes and from, constitution to commercial, civil procedure. It's really up to your choice with some restrictions, but you have variety of options. And once you take those classes, you can understand the whole, overview of these legal areas. So I took the, common law class as well, an American Constitution. So that is the best part of the university, the legal education of University of Tokyo. Talking about Harvard University, I took so-called LLM program. So it's a one-year program open to those who have already a law degree in your home jurisdictions. And as you know, Harvard adopts so-called Socrates method, which means you don't really learn the subject matter of the law, but you learn how you think, how you apply the law. So once you finish 1-year program, you do not necessarily understand the details of law itself, but you understand, you learn how to approach law in United States. So that's something I didn't learn in Japan, and that was really fascinating part. And those discussions I conducted in the classroom was very fascinating. And also the best part of the LLM program, particularly at the Harvard, is you get to know students from around the globe. There are almost 100 students around there, and they are coming from more than 50 countries. So you have friends all over the world, and you still continue the relationship after 25 years. And we still have a reunion among LLM. That is the beauty of LLM program in United States.
That's brilliant, Yoshimi. Have you had one recently in COVID times?
Yes, we have, Zoom reunion. Yes.
Just like how we're doing now, I guess.
Yes, indeed. And we have, SNN chat room. So we exchange, conversations almost daily.
Oh, brilliant, brilliant. So I know a lot of young practitioners are considering, getting another qualification or studying abroad. Is there any advice that you would give to those considering, either studying abroad or gaining some experience in a different jurisdiction?
Yes, of course. If you want to be involved in international legal practice, and depending on where you practice law, you may wish to choose, you may wish to study abroad, like, country in United States, or sometimes potentially it could be UK, to be exposed to, first of all, different legal system. I'm from civil law jurisdiction, so I wanted to study common law and get the qualification of common law. So the easiest option for me around that time was, LLM of United States. So in terms of familiarity with legal system of different jurisdiction, it is a great opportunity to study abroad. That's number one. And number two, particularly if you want to change the working place, if you want to, for example, join law firm in different jurisdictions, of course, it's better to get the qualification of that jurisdiction. So I, worked briefly at Covington Burling, following the Harvard Law School LLM program. That was possible partly because, I, got the LLM at Harvard, and also, took the bar in the United States. And also thirdly, as I already mentioned, if you want to make friends outside your country, the best way to do that is join that kind of program overseas, which attract so many students around the globe.
Yeah, that's brilliant. And going into the early part of your career, you already mentioned, Covington and Berlin, and you were a foreign trainee there. You actually started practicing in Japan in the early 90s before obviously starting your master's in Harvard. And then after that, you stayed there to work in the US. Can you share with us one memorable occasion during your time in the US, working in the US?
Yes. Well, first of all, there are a number of, memorable events out there. But one thing I can highlight is to get to know how female practitioners are working in the United States. Female lawyers are working in the United States. As I mentioned, around that time, it was not easy for a female lawyer to practice in Japan. Few law firms wanted to hire female lawyers, and Japanese companies didn't necessarily appreciate, counseling by female lawyers. But I could find a sort of role model in the United States to see female lawyers actively practicing, even young, female lawyers, junior female lawyers, actively participating in practice. It was really fascinating opportunity. And I could find role model in the United States. That's the best part of my experience in the United States. And second, I worked in Washington, D.C. office on Covington Burling, and I realized how, U.S. lawyer, particularly those working in Washington, D.C., top-notch firm like Covington Burling, handles the matter. Very professional, working style that was quite remarkable. And also clients treat Washington firm as, the firm of the world, not just they consult with US firm located in Washington, D.C., not only about, law in the United States, a law in Washington, D.C., but they consult with those law firms with respect to the law in all sorts of different jurisdictions, including Japan, Asia, in Europe and Africa, and South America. So the scale of practice and scale of work that I experienced in Washington firm was really exciting.
And you mentioned role models there. Did any of these role models become almost your mentors in your earlier career?
Yes, indeed.
And do you still keep in touch, I guess, or have you had?
Yes, of course,
models?
of course. I'm good at keeping, connection with those people. Yes. They, sometimes you lose connection, but sometimes, we resume connection and you bump into them, unexpectedly. That is really nice moment.
Yeah, and what I found with obviously the COVID and things going virtual is that it's a lot easier to keep in touch with people internationally as well.
Indeed, like, having Zoom meeting, it's so easy. You felt a bit hesitant to call them up, but now, having this kind of video call facility, almost, available for free, it's very, very nice. It's a silver lining of COVID era.
Yes, I totally agree. So after Covington and Burling, you went to work in-house as a legal counsel in an electronics manufacturing company. Can you share with us why you decided to go in-house?
Yes, this is just a coincidence, just like many other events that happened to me in my life. I took a leave of absence 3 times in my life. First was the time I spent in United States for studying and working in US law firm. And second, right after I had the first child, baby, then, my husband was moved to another city in Japan, and I wanted to go together because I needed a break after, having a long hour. And around that time, there are few in-house in Japan, in-house lawyer in Japan, qualified lawyer in Japan. So it's quite rare opportunity for me. And I thought, I was wondering whether I should join a law firm in that city, or perhaps, join a company and to serve as in-house, although it is almost virtually the first in-house in that company. And I took the latter option because I thought it would be more interesting and adventurous and may find, new matters. So I have to get permission from the bar, and I have to pay fee to the bar association, to get the business permission. Around that time, I have to, lawyers have to take business permission from the bar association to join companies to serve as in-house. I, I didn't expect that kind of onerous procedure, but it turns out that was the case. And but I think I made a good choice. I get to know people. I get to know how company operates, the role of legal departments, and complexity of managing all sorts of matters relating to involving legal issues within a huge company. And that is one of my assets during my, my time when I took the leave of absence.
Yes, absolutely. I do think, a lot of the times in our advice, there's got to be the commercial aspects to it and, the practicalities, and having an in-house role kind of helps you understand what those would be and the difficulties of obviously the in-house legal counsel as well.
Indeed, indeed.
Yeah. So when did you decide in your career to go into arbitration and specialize in arbitration?
Indeed. Again, it's coincidence. So I started, as Ben nicely, introduced myself. I started as a I started my practice as a corporate lawyer, or almost general practitioner, handles corporate matters to sometimes tax matters and also security matters. So I've done all sorts of different area of law. And then when I joined this company as in-house, I had to deal with so many intellectual property disputes, primarily patent litigation in United States. Around the time, many Japanese companies are sued in United States based on patents. And then after I came back to Nagashima Ono Tsunematsu, the arbitration is not really the main practice area in Japan around that time. It's very, very, rare event for law firm and for companies. And because, I was away from law firm for a couple of years, and because, there were no one who was interested in doing arbitration, I was asked to take care of it. That was my very first arbitration experience. And because I was involved in Japanese companies sued in United States, litigating United States, I could see the clear difference between Japanese litigation and US litigation and arbitration, and immediately found the benefit and virtue of arbitration, because, either you litigate in Japan, there's some difficulties in, getting evidence because there's no discovery, and awards tend to be smaller. And you litigate United States, there are extensive, discovery and costly, and you have to deal with jury, which is the most difficult part for non-US parties. So arbitration, it's like, more like neutral dispute settlement procedure, and each party, it is easier for parties to achieve level playing field. And I see that benefit immediately and decided to focus on this practice. And because there are few people focused on arbitration, I tend to do more arbitration since then.
Okay, that's brilliant. And I liked, how you still kept the kind of US element within your early career, obviously having gone to Harvard and Covington and Berlin, etc. Is there anything that you would change about your early career? And if there is, what would it be and why?
You mean the change practice from corporate to arbitration, or
just anything, in terms of breaks, or changing from corporate
Sure.
to arbitration, etc.
Yeah, I mean, as I mentioned, all those changes coincidentally happened, and it was guided by clients' need. So now, many clients are looking for those who focus on arbitration or international dispute settlement. And therefore, I shifted my practice area. It's not that I wanted to change, it's more like led by our clients. So perhaps in Hong Kong, there are people who only do arbitration. But in Japan, for example, our practice dictated by clients. So if clients want us to mediate, we do mediate. And if clients want us to engage in settlement discussions, we engage in settlement discussions rather than, going arbitration. So we just follow what client would like to achieve. So sometimes we start arbitration, but we end by mediation or by settlement discussions. That way, that way, I personally shift my practice area. That is, how I change my practice. It's not that, I wanted to do X and next I wanted to, do B and Y. It's not how I shifted my work. I simply follow what I was expected to do, and that's where I am now.
Yeah. And Ben gave a very good summary of your kind of practice to date in his introduction, and we know that you act as counsel in arbitration. You also sit as arbitrator in international arbitration and lecture at Keio Law School. Which aspect of your work do you enjoy the most, or do you find the most interesting?
Yeah, I mean, arbitration practice is such a fascinating practice area because you get to know people who do not always, work together. You almost always have to work together with counsel from multiple different jurisdictions because international disputes involve multiple different legal aspects of different jurisdictions. So get to know people, and you learn new things in different jurisdictions, and the different approach to law, different business practice, and different dealings with law. That alone is very, very interesting. And so even with co-counsel, we do not necessarily agree with the approach or analysis. That is very fascinating. During the course of deliberation, you realize, how different people approach things, legal issues, and try to find common ground and to come to the conclusion that is palatable to, almost all the people. That is the most fascinating part of arbitration.
Yeah, for sure. I think out of all the different roles that you have, you must learn from different aspects of it and bring them, to the other roles as well.
Yes, indeed. And that happens in the course of education as well, because I'm teaching LLM students at Keio University, which means students are coming from different jurisdictions. So I encourage them to share their own legal system and experience so that other students in the same class can learn from people from different jurisdictions. So I try to encourage students to open to different perspective or different analysis of law from different jurisdictions, because that's how we deal with arbitration every day. But in spite of all those differences, the beauty of law is you'll be able to find consensus, some consensus at the end of the day, because the approach of law, no matter how superficially different, the concept of justice we share. That is another fascinating element, because even when you use different language, different legal concept, but sense of justice we share. That is again another fascinating part which you encounter, you find in arbitration practice.
Yeah, that's very, very inspiring, Yoshimi. I know you have a lot of different roles as well. You're vice president ICC, LCIA director in JAA, board member in the Swiss Arbitration Association, and International Council for Commercial Arbitration. How do you manage all these roles?
Well, perhaps I do not properly manage. In fact, perhaps I should have done much more, but and perhaps resolution for next year, I perhaps do more contribution to each organization, which allow me to participate, to share different perspective, to increase diversity in many senses. So I have to say that I wish I could contribute more, but I haven't done more. I would do whatever I can do in my, time, but usually this kind of work tends to consume my time. I wouldn't say over midnight, but over weekends, or when I find extra time, I will spend time for these kind of matters. But perhaps I should have done much more.
I'm sure you're being very modest there, Yoshimi. You're already contributing a lot, and we can see that with the IBA work that you've been doing. So in your view, what do you think are the biggest challenges in international arbitration?
Yeah, I would say, international arbitration I mean, it has been said by many people, but arbitration becomes too expensive and too time consuming. It's particularly for, companies in civil law jurisdiction, I'm afraid. This is very unusual practice. This cannot be a kind of daily dispute settlement, mechanism, because it is too costly and too complicated and too time consuming, and companies will go away from arbitration, will find a way to settle dispute without using arbitration. Perhaps mediation or simply settlement discussions or whatever, alternative dispute settlement procedure they will explore. Or perhaps, ODR, online dispute resolution, may flourish. Then arbitration that we practice on a day-to-day basis may, perhaps not disappear, but people, will stay away from arbitration. So we have to really seriously think about how to effectively, manage arbitration, to keep arbitration, preferred dispute resolution mechanism. That is my, I sense that kind of challenge and frustration of users, and we need to deal with in Japan.
Yes. And how can young practitioners help, to make a difference in international arbitration and some of the challenges that you've just mentioned?
Yes, perhaps, they can project new perspectives. We tend to follow the standard practice, but, junior practitioner, younger practitioner, it doesn't necessarily, mean that they are young, but they enter into this practice area relatively recently. They may have a lot of questions. Why do we do this? Why do structure this settlement in this particular manner? And they should voice their concerns or questions in the forum like HK45, and ask questions to senior practitioners, serious questions. Perhaps they may wish to engage discussions with corporate counsel and identify the best practice. So I think this fresh view will surely contribute to the development of arbitration practice, which is more palatable to most of the users, particularly in civil law jurisdictions.
And I know some of our audience might be wondering, how can they get involved? Where do they start?
I mean, my first recommendation is get involved in arbitration community like HK45 and find an opportunity to express your own views. Well, get involved in arbitration community like HK45, you will have an opportunity to learn. First, you have to learn what is going on, what is expected to do. And then at the same time, you formulate your own idea and express these own ideas either in writing, like blog, or if there is any opportunity to speak, take that opportunity as much as possible, even though it might sound a bit overwhelming to you, but never be overwhelmed, and try that opportunity. Particularly if you're a junior, you are young, there's nothing to fear about, failing, better to fail by doing something rather than, doing nothing. So be courageous and adventurous.
That's a very good takeaway, Yoshimi. Looking at diversity now, does diversity in arbitral panels and practice enable better decisions to be made in your view?
Yes, indeed. As I mentioned, practitioners from different jurisdictions have very diverse view. If decisions are made by arbitrator from one jurisdiction or less diverse jurisdictions, then decision may not necessarily reflect the parties from different jurisdictions. So right now, unfortunately, in spite of the effort of diversity, particularly jurisdictional diversity or racial diversity or age diversity, we're still in the middle of our efforts. In terms of gender diversity, we have tremendous progress, yet we are still in the middle of this efforts to achieve the true gender diversity, but when it comes to jurisdictional diversity, we have a lot of challenges. So I believe diverse tribunal will tend to come to more balanced conclusion, taking into account the parties' perspective and different business perspectives. I've been involved in a couple of arbitration where, the parties are all Asia, but arbitrators are all from, Europe. And then I read the award, and I could see the difficulties for European arbitrators to understand the factual background of the dispute. They do not necessarily appreciate specific business practice in specific area in Asia, and they are a bit confused why parties are doing this. If we are bringing the claim, why parties are, making compromise, or why parties are making this kind of conversation between the parties, they don't appreciate. So people who understand that kind of business practice would better appreciate the fact, and particularly commercial arbitration, the fact really matters. And it's better to find arbitrator or tribunal who appreciate the facts correctly. And from that, for that reason, I strongly believe that diversity of decision maker, the tribunal, is really important. And that also leads to the diversity of counsel, because, without counsel properly convey that kind of diverse background to the tribunal wouldn't appreciate. And also counsel may not be even able to identify that kind of unique aspect of the facts if the counsel are not from that region, or do not necessarily appreciate the local practice. So arbitration is, a combination of global and local. You have to have those both views, and that's why I believe, diversity is really the key to have successful arbitration that will be acceptable to everyone.
Yeah, for sure. And you mentioned earlier that obviously when you first started in your early career, there wasn't a lot of females, especially in Japan. Has that changed now in terms of females in private practice?
Yes, indeed. I mean, the circumstances dramatically change over time. Now, we want to hire more female lawyers. We want to see more female lawyers in our firm, and many firms have the same policy. They try to hire female lawyers, female students as a new lawyer. And also some clients would like us to involve female lawyers, like, clients in the United States, they prefer to have the team led by female lawyers rather than, male lawyer, and they sometimes check the team and to make sure that the team is diverse. So again, this is not necessarily always the initiative within Japan. It might be a Japanese practice have been influenced by United States and Europe, where companies, clients emphasize diversity, not only within their companies, but also law firms, advisors. So that helped. And because of that, and because of SDGs and ESG, law firm itself tried to promote ESG and the SDGs. So it is an opportunity for female lawyer, but there's a pipeline issue, as you know. There are still fewer female female students in law school. In my time, only 5% are female students, and out of 630 class, only 30 are female students.
Oh,
yeah, nowadays I think about 20% are female students, but still, far less than half. And we hope to see more female students and female practitioners joining our firm in private practice in general.
For sure. And I know from our previous discussions, something that really resonates with me is when you said our services are defined by our people. So in terms of getting, more diversity and diversity of thought, I agree that, it can only mean better things. How, obviously you've talked about the Japan element, how can we, achieve this in Asia Pacific, looking a bit wider than just Japan, and who, in your view, can really affect, influence this change?
I think the Asia, talking about diversity, I think, particularly gender diversity, we are still relatively behind compared to Europe and United States, as I mentioned. US clients and European clients want us to achieve more gender diversity or diversity in general, but it is quite rare when Asian clients ask us to achieve diversity. So the question, the answer to your question is, we ourselves has to take the initiative to expand diversity, particularly younger people like you. We should emphasize, we should voice our concerns and persuade law firms and also clients why diversity matters. So I think each of us, particularly younger one, should take initiative and voice your concerns. That would definitely escalate the process of, enhance the process of diversity.
Mm. Yeah, and I guess, it takes everyone to kind of try to make a bigger change as well.
Yes, indeed, indeed.
Yeah. So I think enough about obviously the work side. Let's explore what you do outside work. So can we start with what interest you have outside law?
Outside work, in this corporate era, you keep working almost 7 days a week. So it's really hard to define when is the weekends. That is the difficulty in this corporate era. But I try to do more exercise, and particularly after COVID-19 pandemic started, I do jogging in the morning. Well, not every day, but try to do at least, a couple of days a week. And also, personally, I like art. I'm an art person. So, well, it's hard to go to museums nowadays. So it's getting difficult to go to museums. Since after the emergency declaration lifted in Japan, I started to go back to museums to see exhibitions. And also one of the my reason for enjoying arbitration is going to the hearing or conference in different jurisdictions and visit art museum and also local market. So I hope, well, virtual hearing is wonderful. It's greener, save time and flexible. But at the same time, I miss this in-person hearing so that, I can explore local museums once again. So look for that moment, time sometime soon.
Yeah, fingers crossed. I think we're all hoping maybe next year.
Yeah, indeed, indeed.
Yeah, and you mentioned that obviously the work obviously consumes a large part of your time. How do you manage your work-life balance? Obviously, you have a family. You have a lot of responsibilities at work as well. Where do you kind of draw the line, and how do you find that balance?
It's a good question. I have 2 children, and they already become the elder one is going to start working next year. So I do not need to take care of them anymore. But when I was senior associate and I have 2 kids, it was really challenging time. partly because I'm almost the first associate who had baby in our firm. So there was no system at all to, deal with. There was no maternity leave or paternity leave, even more. No concept of that. So law firms did not know, our law firm did not know what to do with, pregnant junior, senior associate. That is one of the reasons I took the leave of absence immediately after I have a baby. But my recommendation to younger, so perhaps in terms of work life and also personal life, around 30s or perhaps mid 30s, you will go through the busiest time of your life. Personally, you may have bigger family you have to take care, and also professionally you want to achieve, you want to achieve more things. Maybe your responsibility will become bigger. And so your personal and professional responsibility is expanded almost simultaneously, mid-30s or 40s. And that is really challenging time. And well, there are a couple of ways to deal with this. Of course, the working environment should be improved so that there will be less, challenge imposed to these generations. And there should be more fringe benefit or some, some arrangement so that these people can work in a more flexible manner. And in terms of evaluation, they should be fairly evaluated, not just looking at the hours, or not just looking at the product, but more overall assessment. But what I would say to, first of all, those people who are in the middle of this, very intensive period, be relaxed. I mean, life is longer than you think. And thanks to this qualification as a lawyer, you can, earn your expertise. You can build on your expertise even if you have break. So don't worry too much. Don't feel overwhelmed. Think more longer perspectives. That's number one. And number two, at the same time, you should not, how should I say in English? You should not, you should refrain from decided not doing something because of someone else, because, my husband was transferred to another city, I give up career. Or because I have a baby, I, give up something X. That kind of negative, thinking is not really helpful at all. You may be, your career might be interrupted, but don't, think it in a negative way. Think about, take it as it from the positive perspective, and think about how you may use this opportunity. Don't consider it interruption, but consider it an opportunity to do something else, and or perhaps switch career, or enter into a new practice area, or maybe park there for a moment and think your own practice, and then resume your practice. Maybe after break you may study abroad. Then you may wish to build a new practice area, or maybe you may wish to find a new working place. So think about constructively, positively. And thirdly, don't try to do it everything on your own. Find helpers in working place and also in your private life. So when I was, I went through this quite intensive time. There was a kind of stigma for female practitioners to send their kids to daycare. There is a myth that mother has to take care kids on their own, at least up to 3-year-old. That is, I believe, myth, and I think I proved that it was in fact myth. But none, in spite of these, sort of stigma or myth, I decided to send my kids to daycare, and I have nanny, I have helper in my home, so that I will not be stressed out. Because if I were stressed out, perhaps it's not helpful to my family and kids and my professional life. So just, rely on helpers. And it's not, it's not free, of course. You earn things, you work hard and you earn money, but you immediately consume these money by paying, those helpful helpers. But this doesn't this doesn't continue forever. This certain period of time, perhaps you may earn money and you spend immediately to hire these helpers, but that will enable you to continue your practice, continue good relationship with your family, and keep calm. So that is the third, point that I want to emphasize.
Yeah, I think having an extra pair of hands are definitely Yoshimi at stages in time. Right. I will probably just go to, because we've had some questions in, so if you don't mind, maybe
Sure.
we'll go to the Q&A. The first question is from Aria, and she says, thank you for your excellent sharing. Many countries are establishing overseas development zone or other countries. What are the most common difficulties arising from this kind of cross-border litigation or arbitration in your view?
Well, it all depends on the circumstances. Sometimes cross-border litigation or cross-border arbitration, in some jurisdiction, arbitration practice or litigation practice is not that established, or sometimes, there's corruption and inefficiency in the system in certain jurisdictions, and even arbitration is considered to be international dispute settlement, which is not confined to one legal jurisdiction, but still, unless it is exit arbitration, it is confined by the law of the seat. So inevitably, if there is inefficiency in these jurisdictions, cross-border arbitration litigation inevitably experience those inefficiency. That's one of the challenges. We hope to see the litigation practice and arbitration practice will further developed in the jurisdictions where these practices are relatively young. In Asian country, Japan as well, there is room for improvement a lot, and that is also true in many jurisdictions in Asia. So we hope, Hong Kong arbitration practitioner, young Hong Kong practitioner, young arbitration practitioner, not only developing its own practice in this Hong Kong, but also go outside Hong Kong and do practice, or get to work with practitioner in these jurisdictions to expand the sort of best practice. And the good thing about arbitration is that's what you can do.
For sure. And another one of our audiences wanting to find out more about your in-house experience, where you mentioned you dealt a lot with intellectual property matters, and they wanted to know how often is trade custom of relevance to any dispute or contractual agreement in international work.
Sorry, could you
Yeah,
elaborate?
so the question was, in your experience in dealing with intellectual property matters, how often is trade custom of relevance to any
Trade
dispute?
custom.
Yeah, or
Trade
contractual
custom.
agreement in international works.
Yeah, I mean, there are two types of intellectual property disputes. One is, based on contract. The other is, of course, not based on contract. So patent holders or copyright holders can just sue in the relevant jurisdictions anywhere in the world. So the complaint may fly in from any jurisdictions. That's what I experienced as an in-house. But at the same time, there's a contractual disputes, and many of the contract involving intellectual property, like joint development contract or license. There are many sorts of contract having intellectual property aspect. And they tend to have arbitration clause. Traditionally, some people concerned about arbitrability of patent relating dispute, but so long as you are not going to try to invalidate the patents in the arbitration proceeding, except in certain jurisdiction, you're generally okay to, arbitrate patent disputes. In fact, I've done both quite a lot, and my first arbitration, in fact, involved a joint development joint development agreement in United States involving patents.
And I think we're seeing a lot of our audience is interested in specific areas, right? So how do they get more knowledge if they do have a specific interest in one area?
In terms of arbitration, or
in terms of arbitration, either, I guess, if they're interested in, for example, intellectual property type disputes.
Sure. Yes, in fact, I do all sorts of different, dispute area, and I find it quite fascinating. I always find new area quite fascinating and try to learn as much as possible from each case. And right now, because I was designated by the government of Japan as the panel of arbitrator of exit. So I hope to expand this area as well.
Yeah. Fantastic. And one last question. How was your experience working in the US in terms of adjustment to the US work culture, work ethic, writing style compared to Japan? I think you've already mentioned Japan is obviously civil law system, US more common law. So would you mind telling us your view on this?
Sure. Yes, for myself, talking myself, particularly in, I guess it was late 1990s, everything was new to me. I learned a lot from US practice, both writing and team working and allocation of task among the team members, and organizing conferences by junior practitioners. And the role of junior practitioners within the law firm was quite interesting. In Japan, there's a kind of seniority system. So essentially, you wait until they wait for the instructions for senior. But in United States, even it was 1996, the junior associates took initiative in organizing, many conferences, inviting firms, clients. That was really fascinating experience to me. And perhaps, nowadays, I think, US practice, US law firm practice more, sort of digitalized. They have perhaps introduced a lot of AI technology. And if you go there now, you will see more interesting element. Perhaps that's my guess. But the difficulties at this moment is US visa restriction is harder. it's perhaps, harder to get a job in the United States. So if you wish to have working experience in a US law firm, perhaps you want to check, visa status first to see whether it's it makes sense to, pay high tuition to study United States and get a job there.
Brilliant. Thank you so much, Yoshimi, for this great sharing. I think we've slightly gone over time.
Okay.
But on behalf of Hong Kong 45, I'd really like to thank you for joining us today and for your kind sharing. And thank you also to our audience for joining us today. And we hope everyone has a fantastic Friday tomorrow and the weekend ahead.
Thank you very much, Jennifer, for a wonderful interview session. And thank you for those who participated. Have a great weekend.